Welcome to Legal Lines. My name is Tom O'Shea, the host of this program that is brought to you by the York County Bar Foundation. My guest today is attorney Tim Colgan. Tim is an attorney with the law firm of Colgan and Associates with its office in Dillsburg, Pennsylvania. Welcome, Tim.
Thank you.
And our topic today is collaborative law, which gets me to my very first question. What is collaborative law?
Good question. Collaborative law is another means for people to resolve disputes, and that can be a method of resolving disputes in family businesses, estate matters, but primarily we see it in domestic disputes, divorce, child custody, matters of child support, alimony, things of that nature.
So it's a process that could apply to any area of law, but what do you concentrate in the domestic arena?
I do. My area of practice is primarily the domestic arena.
Okay. And what exactly does it mean when you take a case as a collaborative law case?
In a collaborative practice setting, the parties to the case agree that they're going to resolve their dispute within the confines of a series of meetings between themselves with their lawyers in an effort to try to preserve their resources and move forward with their lives and make decisions for themselves without having the courts make decisions for them or allow third parties to make decisions for them about their future and about the outcome of the case.
So in a way, it's a process where the parties agree to stay out of court.
Correct. They agree to avoid court altogether or to at least delay litigation. Not every collaborative case ends in a successful result. So people always have the option to return to litigation, but while they're involved in the process, they agree to delay or suspend that.
So if I'm a client and I come to you and I have a domestic case, and you explain to me what collaborative law is. Well, why don't we just do that?
Sure.
You explain to me as a client.
Sure.
We'll play role play here.
Sure.
And I'm the client. Tell me why I should take the case as a collaborative law case.
Well, you have a couple of choices when you come to me as a client that I'm going to talk to you about. You have the possibility of handling your case between you and your spouse at the kitchen table, as we refer to it, the kitchen table method. You could choose to go to mediation. In mediation, you have a neutral third party who's going to work with the two of you to help you get to an agreement. Or you could do the collaborative method, which is each one of you have an attorney that are going to represent you at the table as you try to negotiate agreement on matters of the distribution of your assets, matters of child custody support. Or you could go what people think of as the traditional route, which is the litigated case. And in the collaborative approach, you have representation at the table. You have someone who's working with you to try and help you reach an agreement that is centered on you and what's best for you going forward. It's centered on something called interest-based negotiation, meaning we want to avoid the traditional tug of war over that happens in many cases. I want to have this particular item or this asset just because I don't want you to have it. We want to focus on, does that asset solve or satisfy a need that you have for yourself going forward? So what are your interests going forward? And that's really one of the hallmarks of the collaborative process.
Okay, now with collaborative process, each party is represented by an attorney.
They are.
Now you mentioned a different process, which is mediation. I want to point out that you are also a mediator.
I am a mediator as well.
Okay, now with mediation, both parties would come to you as the neutral party.
Correct.
You're not representing either party.
That's right.
And your goal is then to get the parties on their own to come to an agreement.
Correct.
Okay? With collaborative law, there are two attorneys involved.
Correct.
And each attorney is representing his or her client's interest.
Absolutely.
But there's no neutral party. There's no person to decide the case if they don't agree.
That's right. There's nobody there to make decisions for the parties. It is their process. They make their own decisions. It's one of the most powerful parts about it. People really latch on to the idea that they are going to control their future and going to control the outcome as opposed to someone dictating to them, this is how it's going to be. This is the schedule that your children will spend at your home. Or this is how many dollars will change hands between you. Or this is who will ultimately receive the family home. These are decisions that the parties make by themselves in the process with the support and guidance of their attorneys. Now, there can be neutral third parties who are involved in the process. It might be a financial specialist who is brought in by the parties to help them identify what their forward-looking needs and interests are so that we can collectively look at the marital estate that they've compiled and say, okay, how can we help get them on the road to where they want to be? It might be a child specialist, someone who works with the family to help fashion a parenting plan for these folks so that they can do it in a way that meets their needs but also is centered on the children.
Now, would this be somebody who would actually come to a meeting, or would it be somebody who would meet with the parties and write a report? Or
they wouldn't write a report, but it can happen where that individual might come to the meetings if it's appropriate. But one of the things that we focus on in the collaborative process is to be efficient and mindful of the parties' resources too. So if it makes sense for the parents, if they have an issue related to their children and the parenting of their children, it might be appropriate for the two parents to go and meet with a child specialist together without the two attorneys present. Sometimes we involve what are called coaches, someone who may come to the meetings and actually participate in the meetings to help foster the correct form of communication. As you know from having done this work for years, it's not always what is said, but how something is said that can be important. So communication specialists sometimes are involved. The goal is to try to get a team of people assembled, the right team of people assembled, so that we can, as efficiently as possible, help these folks to a final resolution.
Okay. Now, it seems to me that if you take on a case that is a collaborative law case, that the other party, the party you are not representing, also has to sign on to this.
Absolutely.
Okay?
Right.
And that would mean that if they have their own attorney, that their attorney would have to sign on to this.
Correct. And there's a process for the attorneys to become trained in the process of collaborative practice. Just like there's training to become a mediator, there is a training process to become qualified to handle cases in a collaborative setting.
So what would happen if somebody decides they want to proceed down the collaborative route and the other party says no?
Right.
Then it can't happen.
Then it can't happen.
It's just sort of like mediation. It takes
Correct.
two to mediate.
Correct. And both parties, not only do they have to say, yes, I want to do the case collaboratively, but at the outset of the case, they sign a contract with each other known as a participation agreement that outlines certain principles that they're going to adhere to throughout the case. They're going to share information openly. They're going to negotiate in good faith. They're going to negotiate from a place of their highest and best self-interest. Those pledges they make going into the case, as well as the pledge that if they decide to leave the collaborative process, that their attorney is going to be disqualified from representation of them in any form of litigation.
Right. So in negotiating any type of case, whether it's a domestic case, a divorce case, or whether it's a business contract or any type of civil case, one of the things that lawyers constantly use is the threat of going to court.
Right.
I think the expression is, I'll see you in court.
Right.
And with collaborative law, you can't say that.
You can't. It's off the table. It's been one of the most interesting things in becoming a collaborative practitioner is how fearful people are of that very phrase. And oftentimes cases ratchet to a level that neither party wants it to get to because they're fearful that the other party is going to see them in court and is going to do something that's going to land them in court. And by taking that off the table, people really can shed a whole layer of stress and fear and emotion that prevents them from negotiating from that place of their highest and best self-interest. We talk about creating, in the meeting room itself, we're creating an environment where people can negotiate in a way that they really are introspectively looking at themselves and what they need, rather than strategizing or fearing how is this going to come across in court, or what is that lawyer who's sitting across the table from me, how are they going to take and twist my words when we get inside of a courtroom later? They don't have to worry about that, because if the case doesn't reach an agreement, I'm not going to be the lawyer who's sitting in the courtroom against them or across the table from them.
So you mentioned that I think the parties signed some type of contract.
It's called a participation agreement, yes.
So both parties have to sign the participation agreement. I assume both attorneys have to sign on to it.
The attorneys sign as witnesses, but part of our agreement with our clients going into the case is I limit my representation, and they know that if they choose to proceed collaboratively and if that's the way we're going to go, they know that my representation is limited to this collaborative process. And if, for whatever reason, either spouse chooses to leave the collaborative process, they're going to need to get another attorney. It's actually, causes concern.
Well, let me just, I didn't mean to interrupt you here,
Sure.
but if you said that if one party wants to leave the collaborative process, they have to get another attorney. Wouldn't both of them? Because if one person leaves the collaborative process, by default, the other person has to leave the collaborative process.
Correct. Right. And so both parties would have to get new attorneys if the collaborative process came to an end. Now, I can tell you, I've been doing this since 2007, and I've had nearly 30 collaborative cases, and I can only recall one that didn't result in a final agreement. So it's the success rate for collaborative is extremely high, and that's worldwide. This is being practiced in countries around the world, in states across the United States. So this is not local, or this is not a concept only found in York County, and the success rate is extremely high. Settlement rate in almost every case, in every domestic case, most cases result in a settlement, but what collaborative offers people is the ability to craft, it's the quality of the settlement that they're able to craft that I think differentiates it.
Okay, so I am also a mediator. I serve as a mediator for various issues, mainly domestic issues, and I always tell people when they come in to see me voluntarily for mediation that I know that there's a 99% chance they are going to reach an agreement, because they wouldn't come to mediation if they weren't inclined to reach an agreement.
Sure.
They might disagree on things, but the fact that they are willing to participate in this process usually tells me that they, in fact, are committed to staying out of court. They're committed to getting this resolved as quickly as possible and as efficiently as possible, and they're willing to compromise.
Sure.
Because you can't reach an agreement in anything without compromise. We should tell that to Congress, by the way, but this isn't a political show. That's what's so important in here. Now, I suppose what's different from what I do as a mediator, or you do as a mediator, in the collaborative law process, you have some convincing to do with the other attorney.
Well, not exactly.
No,
the other attorney is not. I'm not negotiating with the other attorney. It's one myth, I think, even when people hear about the collaborative process and they talk to me about it as a client who's contemplating going into the process, they envision going into these meetings where I'm doing all the talking on behalf of the client and talking to the other lawyer. But that's not what's happening. These parties are talking to each other and expressing and exploring options for resolution of their own making. I'm there to offer input and guidance on the legal intricacies of some agreements that they're considering, the potential upside or downside to any option that's been explored, some of the roadblocks that might be encountered that would be apparent to you and I from having done this for a long time, but because they're going through their first divorce potentially, they may not recognize those things.
Well, Tim, I'm going to stop you right here because we're about to take a break. This is Legal Lines. My guest is Attorney Tim Colgan, and the show today is about collaborative law. Welcome back to Legal Lines. My guest today is Attorney Timothy Colgan from the law firm of Colgan and Associates in Dillsburg, and the topic is collaborative law. And before the break, we explained what collaborative law is, and as I understand it, why don't you summarize briefly what it is?
Right. Collaborative practice, again, is a method for people to resolve disputes without going to court, handle the resolution on their own, and reach the same durable, lasting agreement that they would get if they were to litigate a case all the way from start to finish.
So basically, it's a method where both parties commit to avoiding litigation.
Right. And commit to achieving a great result for them, the best result for themselves that they can.
Okay. And you told me that there's a 4-step negotiation process in collaborative law.
Correct.
So I want to go over each of those 4 steps.
Sure. The first step, one of the things we talked about earlier was that participation agreement that folks sign and that commitment to openly share and provide information to one another. So that's the first step of the process, is to gather all of the relevant information that folks need so that they can make an informed decision for themselves. The second step is that interest-based negotiation piece of it, which is looking at each individual's needs and interests going forward. Oftentimes people know that or think that they know that they want a particular thing, but they've not given real thought to what need does that particular thing satisfy for them. So they might say, I want the house. But what we try and dive deeper into is, well, what does the house do for you? Is it because it provides stability for the children? Is it because you have an emotional attachment to that house because it's built on your parents' land? Are there other ways that we could satisfy that need other than that particular house? We want to know about those things. And that's really the heart of the process. It's not the natural way that we think about things. We just think about, I'd like to have that car or that house, but not really think about it from our own introspective position of what does that house or that car do for me. So we spend a lot of time with folks on that. And then the third step is generating options, brainstorming, coming up with creative solutions that are outside maybe the way that we would traditionally think about how a solution might be reached. And oftentimes that brainstorming process, it's rare that you have the first option that's accepted or maybe even the second option, but oftentimes it's like a piece of clay on a potter's wheel that eventually it starts to take shape. As you brainstorm, as you work with different options, you get to a place where parties can reach resolution, and that's the fourth step of the process.
So if they reach a resolution, they have an agreement, and then basically it's like any other case where there's an agreement. The attorneys draft the documents that need to be signed to finalize the terms of the agreement.
Right.
And let's say that it is let's say it's a divorce-related case with a division of property. You take that agreement. How binding is it? Is it just as binding as if they went to court and had a full-blown hearing and the judge sat down and said, this is who gets the house and this is how much money the other person pays the other person?
Absolutely. It's every bit as binding. You end up with a contractual agreement as to what's going to become of your property, what might become of particular assets like retirement benefits, what your plan is for the parenting of children or the payment of either child support or alimony, all the same things that you would get in any other forum. So it's every bit as binding, it's every bit as enforceable. One of the things, though, that parties sometimes decide in this process, and one of the things they like about it, is the ability to maintain privacy. So parties will make a decision about whether they want to have their agreement filed with the court or whether they want to maintain and keep that agreement a private agreement between them.
Because if it's filed with the court, it's a public record, it's a public document. Anybody can read how much income you have, what assets you own, what your assets are worth, what credit card debt you might have. That's all becomes public record if it's litigated.
Right.
And if it's done by an agreement, you can control how much you put in the court record.
Absolutely. And it does not compromise the enforceability of that agreement because it doesn't get filed with the court.
Now, that would be true just about in any type of area of civil litigation, or any type of civil case, whether it was a divorce case with a division of assets or it was a contract dispute between two business people.
Right. But this is often something that we talk about as an agenda item when we meet. We want to talk with these folks about what does it mean if we file the agreement, because that's something that oftentimes they've not been through the process. It doesn't occur to them that, wow, this agreement is going to talk about the assets that I own, the liabilities that I have, and now it's going to be filed and anybody could walk into the courthouse and pull that file and read about that. So we'll have a discussion about that. And how do you want to handle it? Is it better to keep that as a private agreement rather than filing it?
Right. Now let's just talk a little bit about the process itself. If I were to agree on a collaborative process for a resolution of let's say it's a divorce case, how long does that take?
It can take, in my experience, it takes anywhere from 6 to 9 months, start to finish, which is significantly faster than a traditional litigated case, because in a traditional litigated case, if there are even though it's a divorce case, there are likely to be issues of division of assets. There are likely to be issues surrounding child custody. There are likely to be issues surrounding support. And those are handled by 3 different branches of the court system. We can deal with them all within the confines of a single meeting room. And so we tend to be efficient in the process, and we can get things done more quickly. The parties control how frequently they would like to meet. So in some instances, they might decide we're going to meet every 3 weeks or every 4 weeks. Sometimes it's more appropriate to stretch those meetings out if we're waiting for other pieces of information. But 6 to 9 months has been my experience. Now, I will say that the parties control this, so we don't ignore the emotion that goes on in these cases. And there are times when a party will say, I just simply need a break. I need to take some time to gather myself before I can continue with this process. And the parties have the ability to manage that as well.
Okay, so you indicated that the first step is to gather information. I'm guessing that sometimes is the lengthiest part of the process.
It can be. It's one of the things that we address at the very first meeting is what types of information do we need and who is going to be responsible for compiling that information.
And in any type of case, whether it's a domestic case, whether it is a contract dispute, what the clients need to know, and I always tell clients, is the more you can get yourself, the less money you're going to spend on legal fees, number one, but number two, the faster that we can get to the meat of the issue.
Absolutely. And that's exactly what we talk about up front is who has the access to information, who has the best opportunity to gather that information and bring it to us. Part of it is because the participants in the process need that information to make informed decisions. Part of it is also to educate the lawyers who are involved in it. We're coming into a situation where we're trying to learn someone's financial life, and we need information to become educated on that as well.
And sometimes you'll need additional information from outside sources. For example, if people need to know the value of the house, the parties might disagree on the value. You might need to get it appraised.
Right, and that's an example of where this process can be efficient for folks, because if you and I were handling a divorce case for a husband and a wife, I might choose to go out and have that property appraised and share that appraisal with you, and you might say, well, I've already gotten it appraised myself, and now we've spent the same money for the same result, really. So we're going to talk about that in the process. Can we agree upon a value for the house? If not, should the house be appraised? If so, is there an appraiser that we can agree upon? How do we want to share the cost for that, if we're going to share the cost for that? So those are all things we follow along with that process, that 4-step negotiating process. We also follow a fairly regimented process in the structure of meetings. We always have an agenda for a meeting so that folks know exactly what we're going to be talking about at the meeting, and the agenda is driven by the parties. So if there's a priority issue that they need to talk about or discuss, maybe the soccer schedule is come out for the spring and we need to know who's going to be running the kids back and forth to practices, we can discuss that at our very next meeting. And we can defer or delay the discussion about what's going to become of the house until the time that it's appropriate to do that. So we follow that agenda, and we take our cues from the participants in terms of what's important to them to discuss at this particular moment.
Okay. Now, so if we could summarize, what are the advantages of a collaborative law process?
Well, I think there are many advantages. One is the efficiency of the process. It tends to be a less lengthy time process in terms of calendar months to get from start to finish. It can also be less expensive. I'm always cautious about giving that kind of prediction because...
Well, that's my next question, actually. Is it more or less expensive than the traditional process?
I can tell you in my experience it's less, and I've looked at in my own practice since I've started doing collaborative work and comparing that to the litigation cases that I've had, and it's significantly less expensive for participants in the process. What I will say is it's compressed expense. Because if we have a litigation case that takes 2 or 3 years to work its way through the system, there are going to be peaks and valleys for that client throughout the process. There might be 3 months where nothing is going on and they're not seeing any kind of a legal fee. If we're doing the case in 6 to 9 months, it's going to be compressed. So while the overall expense, in my experience, is less, it's going to be much more consistent.
Okay. So approximately how much of your time is spent on collaborative law cases as opposed to
In terms of my overall practice, I would say about a third of my practice at this point is collaborative.
And how many other attorneys locally are involved in this process or who welcome collaborative law type cases?
In the central Pennsylvania area, there are about 45 trained collaborative practitioners. In York itself, I want to say there are about 10 collaborative practitioners in York.
Now, it would be important for the opposing party to also go to an attorney who is signed on to this process.
Right, and sometimes if I'm the first person to see a client in the process, I will direct them and give them some information so that they can take that and share that with their spouse if it's appropriate and say, this is a process that I've learned about. I'd like you to read about it and decide if you think it sounds like it could work for us. And then we can give them a list of practitioners who are trained in this area, and they can arrange to have a consult with a practitioner and decide if it's appropriate for them.
Now, one of the things that I want to touch on is you're comparing the time. For one of the advantages you said is that the time frame is much faster, and I know from experience that the time frame for litigation, especially of a divorce case, could drag on for well over a year, sometimes 2 years.
Sure.
Which sounds extremely long to anybody. But when you say that this process could take 9 months, to most people that would also seem like a lengthy process. I think we need to point out that it can be faster.
It can be.
Okay, and part of that is that if the parties gather the information faster, if they come to the table faster, and basically cooperate with each other faster.
Correct.
And the lawyers need to do that too.
Right.
And although I'm going on this, I noticed that we're running out of time here, so I'm going to have to cut it short there and not give you a chance to respond much more to that. This is Legal Lines, brought to you by the York County Bar Foundation. My name is Tom O'Shea, the host of the show, and my guest today was Tim Colgan. Thank you, Tim, for discussing this.
Thank you. Thanks for having me.
Yeah, thank you.